everyone, today we're going to talk a little bit about the role of the marriage and family therapist in divorce-related legal issues. Let's talk a little bit about the general divorce process first. This process varies from state to state depending on where the person lives. When you're married, you cannot be divorced unless a judge signs a divorce decree stating that you are divorced. Then it becomes a legal divorce. The divorce can be one of two ways, either contested or uncontested. A contested divorce is where one of the parties doesn't agree about the aspects of the divorce. The uncontested is where the parties agree about the aspects of the divorce. In South Carolina, where I live, the process starts by completing the following paperwork: a summons and a complaint for divorce, the family court cover sheet, and the financial declaration form. This paperwork is then filed with the Clerk of Courts, Family Court Division, and it can be filed in three different ways. Either it's filed in the counties where the spouses last lived together, it's filed in the county where the defendant lives, or the county where the plaintiff lives. Copies are then served to the defendant by one of a few ways, either U.S. mail, personal services, the sheriff's office, or private process service in order to serve the person that you are divorcing. The next part is then disclosing the financial information. Financial information in South Carolina must be filed in any case heard in front of a court. This includes information about each party's income, expenses, assets, and debits. And finally, the last part is finalizing the divorce. So if there is no response to the complaint, after 35 days, the plaintiff can proceed with the final divorce. They complete a request for a hearing and an affidavit of default for divorce. They also have to show that the defendant was properly served, so there needs to be proof that the defendant was served the paperwork. And then they prepare for the final hearing. They complete the final order of divorce and the report of divorce. And then they have to have one person who is close to them and knows their personal situation testify that the spouses have lived apart for at least 1 year. Okay, so moving on to issues of child custody. There are different types of child custody. There's physical custody and legal custody. So first, physical custody. Physical custody is primarily where the child lives. And there are two types. There is sole physical custody and joint physical custody. So sole physical custody is where the child resides with one parent primarily, and that is considered the custodial parent. They will go on visitation with their other parent, but just spend most of their time with the custodial parent. Then there is joint physical custody, and this is where children reside with each parent for a substantial amount of time. For example, a child may be 4 days at one parent's or 3 days at another parent's, or they go back and forth depending on schedules, especially if the families live close together so that it's not disrupting the child's schedule. So for the legal custody means the legal right to make decision regarding the child's upbringing. This is usually awarded to both parents. Parents have to communicate and cooperate in making these parenting decisions. For example, things like religious upbringing, where and how routine and emergency care is recovered, and if children receive special services, counseling, music lessons, tutoring, etc. Now, if you are counseling a child, you have to make sure that you have permission of both parents in order to see the child for counseling. If the custody is determined outside of court, it can be done by mediation, arbitration, counselor, or attorney. And then once this agreement is reached, it's presented to a judge. And as long as the judge signs off on the custody agreement, then it becomes a final part of the divorce decree. Custody that is determined in court, on the other hand, when this only happens when all other methods fail. The primary caregiver during the marriage or the relationship carries the most weight in this case, and this would be the person that's handling the majority of the caretaking responsibilities, making sure the child goes to medical appointments, school, helping with homework, taking them where they need to go. And if the judge is having a hard time making this decision, then they may use a checklist in order to help out with the decision. For unmarried couples, the sole custody often is awarded to the mother by default. The primary goal for judges in child custody cases is to make sure that the child's best interests are being kept and maintained. Okay, so the next part, moving on to considerations for child custody evaluations. There's a lot of things to consider here. The recommendations are given to both parents and the family court judge. And during the evaluation, the evaluator may interview both the parents and the child multiple times. They may spend time observing each parent with the child to see how they interact. They may gather information from doctors, coaches, teachers, and other important people in the child's life. They may order psychological testing of the parents and the child. These things are all used to help the judge in making the best possible decision regarding the custody arrangement. Non-parental custody is another issue to think about. Guardianship is usually awarded instead of sole custody, and non-parental custody is usually awarded to family members, grandparents, aunts, uncles, cousins, somebody else who is taking care of the child. Grandparents can also seek to get visitation rights for their grandkids, especially when you have parents separating and they're moving out of state and things like that. Grandparents and child custody, the courts will be looking at things like the ability of the grandparents to care for the child. What are the wishes of the parents and the grandparents? What are the wishes of the child, that is, if the child is old enough to participate in that decision? How is the relationship between the child and the grandparents? The grandparents must be able to prove that parents are unfit to continue with the custody of the child if they're looking for child custody. Underneath child custody is child visitation, and there's two parts of child visitation. There can either be supervised and unsupervised visitation, and that just depends. Supervised is when, of course, somebody is there with the parent and the child during the time that they're together, and the unsupervised would be just a child going to visit their parent without that extra supervision. Now, this depends on the parent's ability to be responsible when caring for their children, and if there are any concerns, any mental health issues, any drug and alcohol issues, any concerns, then that would lead to supervised visitation. And the schedule for any visitation must be age appropriate for the children. Some of the considerations for evaluating mental health of caregivers: it's important that attention is paid to the differences between being a counselor and an evaluator, the role of the counselor and the evaluator when you're looking at evaluating mental health of a caregiver. A counselor is looking to develop more of a therapeutic relationship. They're responding with empathy. They're using interventions to help in therapy, where an evaluator is going to remain more neutral and detached, and they're going to provide unbiased and thorough evaluation of the family, refer to counseling if necessary, refer to a psychological or psychiatric evaluation if a diagnosis is necessary. They're not to diagnose in the role of an evaluator. They're to make sure that to review informed consent so that confidentiality is understood, and confidentiality is very different when dealing with the legal system, and that these reports go to the court and cannot be kept as confidential as it would be when somebody's in therapy. Now, the Association of Marriage and Family Therapy Code of Ethic considerations that I've discovered was one of the biggest things is to make sure that clients have informed consent. They understand what is going on with the process, and that nothing's a surprise for them. To avoid multiple relationships, don't be the counselor and the evaluator in any situation. There are limits to confidentiality due to reporting to the courts. And it needs to be separate. The separation of the custody evaluation from therapy, those should never be combined. You want to avoid any conflicts of interest around treating minors or adults, and do not perform evaluations for custody if you're treating any party in a family. Now, releasing information once subpoenaed, the first part of this is a little bit about subpoenas. A little bit about your documentation with clients. First, you're mandated to document any clients that you have with contacts, any client contacts you have. That's very important, because if it's not documented, then it's not something that is part of the record. You want to make sure that you have a comprehensive history, including any domestic violence, abuse, substance use, mental health that is in your in the family. Make sure that the following items are included in your documentation: that you give the content presented in the session, your observations and assessments, your treatment plan and any referrals made, and any consultations that are done. That way it covers you. Now, if you get subpoenaed, this is a request. This doesn't mean that you have to automatically send out a copy of the record to anyone. It's just a request for records. You can respond and let them know that you don't feel comfortable releasing those records if you do not think that it's in the best interest of your client and that you would like to assert client privilege. You must contact your client regarding the subpoena and let them know that you received the subpoena. Your client may want to sign releases in order to disclose the information to the attorneys, and that is up to your clients. And if you're uncomfortable with anything, make sure that you consult an attorney regarding what you should do. The subpoena could be just for your records, or it could be for you to appear in court or for a deposition. Just remember that the court is trying to figure out what's in the best interest of the child with custody situations regarding divorce. So that's all I have for you today, and I hope that is helpful. And if you have any questions, please feel free to contact me. Thanks.